Who owns AI content? Legal questions you should know. In a world where artificial intelligence is rapidly generating content, articles, images, music, code, one of the biggest legal questions of our time is emerging. Who actually owns this AI-generated content? It's no longer a theoretical debate. It's a question that affects creators, entrepreneurs, marketers, developers, and anyone using AI tools like ChatGPT, Midjourney, DALL-E, or Copilot. So let's unpack the legal landscape of AI content ownership and what you need to know to protect your work and avoid legal gray zones. First, let's define the issue. When you use an AI model to generate content, who holds the rights? Is it the user, the developer, the AI company, or no one? Currently, under US copyright law and similar frameworks in many countries, copyright only applies to works created by humans. The US Copyright Office has made it clear, AI-generated works with no human authorship are not eligible for copyright protection. That means if you generate something using AI without meaningful human input, it may not be protected at all. So what counts as meaningful human input? That's where it gets tricky. Let's say you write a detailed prompt and guide the AI through multiple iterations. That could qualify as creative authorship, but a single-line prompt with no edits? Probably not. The line is blurry, and courts haven't fully caught up. Now, let's talk platforms. Different AI platforms have different terms of service. OpenAI, for example, says users own the output they generate, subject to applicable laws. But if the output can't be copyrighted, what does ownership even mean? It means you can use it, you can distribute it, you can monetize it. But if someone copies it, you may not have a legal basis to stop them. In contrast, some platforms, especially open source ones, impose usage restrictions. Others retain rights to reuse or train on your prompts. That's why reading the terms of service is crucial. Let's go deeper. What about using AI to generate content from copyrighted training data? This is where lawsuits are heating up. Several artists and authors have filed legal challenges, claiming their copyrighted material was scraped and used to train AI models without consent. If a model was trained on protected content and then produces outputs that are substantially similar to that material, is that a copyright violation? Courts are still deciding. Some say it's fair use, others argue it's derivative work. This is uncharted legal territory. Now, consider collaborations between humans and AI. Say a designer uses Midjourney to create a visual concept, then manually edits the output in Photoshop. That human-AI hybrid work might be eligible for copyright because of the added human creativity. This suggests a middle ground, AI as a tool, not a creator. So what should you do to protect yourself? First, document your process. Keep records of your prompts, revisions, edits, and how you directed the AI. This can support claims of authorship if needed. Second, understand the platform's rights. Do you have commercial rights? Is there a license fee? Can the AI provider reuse your data? Third, avoid generating content that mimics or replicates identifiable works or living artists. Fourth, if you're building products or services with AI-generated content, consult a legal expert, especially in areas like branding, publishing, or entertainment. Now, what about patents? Can AI invent something? Technically, yes, but legally, no. Patent law, like copyright, requires human inventorship. AI can assist, but cannot be listed as the inventor. In 2023, courts around the world reaffirmed this. Only humans can hold patents. Another important layer, data privacy. When you input data into AI platforms, where does it go? Is it stored? Is it used for training? OpenAI, for example, has clarified that ChatGPT sessions are not used to train their models unless you opt in. But other platforms may vary, so always be mindful of what you share. And now here's the big philosophical question. Should AI content be copyrightable at all? Some argue yes, because creators deserve protection even if the tool is artificial. Others argue no, because it risks flooding the market with synthetic content, diluting human creativity. There's no consensus, and laws are evolving. But what is clear is this: if you want to succeed in the AI era, you need more than creativity. You need strategy, legal awareness, ethical clarity, because using AI is powerful, but misusing it can be costly. This is not a time to be passive. This is a time to get smart about the tools you're using. Know your rights, know the risks, know the rules. Because the future of creativity isn't just about what you can generate. It's about what you can legally own, ethically use, and confidently protect. And that starts with asking the right questions today. So as AI reshapes content creation, remember this: ownership isn't just about having the file, it's about having the rights and the foresight to use it wisely. That's what gives your work value, and that's what will separate creators from copycats in the AI age. Let's shift from legal theory to practical action. If you're a content creator, marketer, or entrepreneur using AI, here are 5 things you can do right now to stay legally smart. 1. Add your human touch. Whether it's editing, rewriting, reformatting, or creatively directing, your involvement strengthens your claim to authorship. 2. Watermark and document. If you use AI to generate designs or videos, consider watermarking them or embedding metadata to prove origin and authorship flow. 3. Don't use AI content blindly in commercial products. Before publishing a book, launching a course, or selling AI-generated images, double-check usage rights and copyrightability. 4. For businesses, train your team. AI tools are powerful, but if misused, they can expose your brand to legal and reputational risk. Create clear internal policies on how your team uses AI. Watch the regulatory landscape. AI policy is evolving fast. From the EU's AI Act to ongoing debates in the US, expect new laws on transparency, authorship, and liability. Stay informed. Also consider registering copyrights where applicable. If you've added enough human creativity, don't wait. Protect your work. In some industries, licensing AI-generated content is already a topic. Stock image platforms are adding AI guidelines. Publishers are revising policies. Music platforms are banning AI clones. The line between creator and curator is blurring, but the law still wants clarity. So your job? Lead with clarity. Create with intention. Use AI as a partner, not a shortcut. Because while AI can write your content, it can't own your legacy. That's yours to define and protect. Let's also talk about AI in collaborative environments. What if a team uses AI to co-create a campaign? Who owns what? Here, clear documentation is key. Define roles early. Decide who owns the prompts, the revisions, and the final product. Treat AI content as a co-authored, tool-assisted process, not a black box. And in the corporate space, consider this. If an employee uses an AI tool on company time, who owns the output? In most cases, it defaults to the employer. But if AI tools are accessed through personal accounts or third-party APIs, ownership can get murky. That's why forward-thinking companies are now updating employment contracts and creative policies to include AI clauses. Expect to see language like all AI-generated outputs used in the course of employment shall be considered works made for hire, or all prompts, datasets, and AI-assisted drafts remain the intellectual property of the company. This is the new frontier of intellectual property, where policy, ethics, and productivity intersect. If you're an artist, you'll need to think beyond aesthetics. If you're a marketer, you'll need to think beyond messaging. If you're a founder, you'll need to think beyond execution. AI is reshaping the content world, yes, but it's also reshaping the rules that govern who profits from that content. So the question isn't just, can I use AI? The question is, can I defend the way I'm using it? In the future, creativity will belong not just to the bold, but to the legally prepared. And those who win won't just create fast, they'll create with foresight. Welcome to the age of responsible AI creation. Your move. Before we close, here's the final takeaway. In a world of generative content, speed alone is no longer your competitive edge. The real edge? Legal clarity, creative control, and the discipline to build content and companies with long-term integrity. If you want to stand out in a market soon flooded with machine-made content, you need more than tools. You need authorship. You need trust. You need strategy. And the smartest strategy of all? Know where you stand before you press generate. Because one day, that content you created in 5 minutes might end up in a courtroom. And when it does, you'll want to know you made the right call. So keep creating, but do it wisely, informed, intentional, and ready for the future of content, where law meets innovation. That's how you lead the AI era, not just as a user, but as an owner. Because ownership, in the end, isn't about algorithms. It's about accountability. And you're ready for that. Let's build.